Good morning to all of you. Normally, all the police officers, they think that according to the AP police manual, they can open rowdy sheets, history sheets, KD sheets, habitual offender sheets against the unsocial elements or the criminals or the offenders and can have surveillance over them. This is based on the procedural aspect of the police manual, which is the Bible for them. But we are all aware that Constitution of India is the mother of all laws. So it is the grand norm or it is the basic law. So whatever law, whatever rule or whatever GO is made or framed should not be against to the Constitution. Please remember, there is no statutory instrument that deals with the surveillance. So this is, of course, time and again the courts have been reiterating the same. But the police officers, they do have this opinion and they can say that they can put anybody in jail and they can maintain surveillance or they can order anybody to go away from the place. All these things they are under the impression. So to give a clearance on this, now let us discuss on the case filed as a writ petition by Mr. Thumugunta Madhava Reddy of Boinpalli, Second. This Thumugunta Madhava Reddy filed writ petition number 18726 by 2020. Right, it was disposed on 19/1/2021 by the single judge bench of AP of Telangana High Court, Justice P. Naveen Rao. So the High Court held that the surveillance should be to the barest minimum. That means the person should not know that he is under surveillance. And the police authorities definitely, if at all they wanted to visit or they wanted to surprise this house, the visit should be only during time and not in the dead hours of the night. Right. Now, if you go into the facts of the case, Mr. Thumugunta Madhava Reddy is a resident of some area in Boinpalli police station limits. A rowdy sheet has been opened against him since he is involved in crime number 387 by 2005 under section 447 and 506 IPC. 447, it is criminal trespass. 506 means criminal intimidation, that is threatening some persons. So this is the starting of his career as a rowdy. So since he was, as per the Police Standing Order 601, a rowdy sheet can be opened against a person who cause disturbance to the peace or disturbance to the law and order, or who habitually commits offences against the public order. So this is normal in brief. So persons who are bound over under section 107 twice, 3 TN syntax twice, who are involved in case, all these things, according to the police manual, they know it very well, better than us, right? A rowdy sheet can be opened against him. So basing on this, since he was involved in intimidation, that means threatening of the public, a rowdy sheet has been opened against him. But incidentally, the case which was charged, it ended in acquittal in 2012. So now, as usual, since it is opened in 2005, after he becomes old or after he once again he becomes a normal person, he has rescinded from the rowdy activities, it can be closed also, right, by 2012. So the case ended in acquittal. But once again in 2019, he was involved in another case in crime number 417 by 2019 under same sections 448, this house trespass, 427, 323, 354A and 506 of the same PS. So another case was registered. Not only this, he was involved in a murder also. in crime number 474 by 2019 under section 452 trespass into house forcibly and 120B conspiracy 302. Right. So this was also charged and it is pending in the court. So in the meanwhile, since he is causing disturbance to the law and order or public peace, a bind-over case was also booked against him in crime number 283 by 2020 under section 107 CRPC. This is the story. Now, he has filed a petition before the Honorable High Court stating that the police of particularly Boyenpalli police station, they are coming in the dead of night every alternate day, and they are calling his doorbell, disturbing his sleep, and making his image lowered in the eyes of the other apartment people. And added to this, he has submitted the annexer with the copy of the CCTV footage. The closed circuit TV cameras, they are showing the police people in uniform, sometimes in mufti, calling the bell. He's coming out with lungi, he's talking to them. They are using the so-called language, whatever varieties, all these things, they are recorded there. Now this is produced before the court. Now, the court having gone through, of course, the AGP, normally on behalf of the government, he says that this fellow is an anti-social element. For that purpose only, according to the police manual, they have a open history sheet. Since they open history sheet, they have to know his movements. For knowing his movements, they have been going in the house. Of course, they are not disturbing him, just they are going and inquiring as to about whereabouts or so these things. So according to the procedure established by law, or according to the due procedure, we can't say established by law, according to the due procedure, they are doing their job. So this writ petition will be dismissed. Of course, the court says that there is no statutory element which deals with the opening of rowdy sheets except your police proceedings or police manual. So even the instructions in the police manual say that the surveillance should be unobtrusive. Unobtrusive means without going to his knowledge. Without his knowledge, you can check his movements. No doubt, you are the duty. The duty of the police is to keep a surveillance on the movements of the suspected persons. For that, you need not deliberately go disturb his sleep because it is violating of Article 21. When a man works for the whole day and he strives for the whole day, he wanted to have a sleep, happy sleep, sound sleep in his house, or he wanted to enjoy with his family members, but he should not be disturbed like that. So this is what is reiterated. Previously, there is a famous case also. Sunkara Satyanarayana, represented by Principal Secretary Government AP, and others versus State of AP, I think 1999. So in this case, of course, that Sunkara Satyanarayana was a truck driver. He was involved in a theft case. A KD sheet was opened against him. Same thing happened. Police people coming and disturbing him, and he has filed a petition in the High Court. There also, the court clearly stated that you can maintain unobtrusive watch, no problem. But it should not be known to him and he should not be disturbed. This is the main plot. So now the Honorable High Court held that, no doubt, even though you say that you have got a procedural power to register a rowdy sheet or KD sheet or history sheet, but the surveillance should be to the barest minimum. Whenever you get it out, you can check him, but you should not make it a formality to go into his house and check his movements. That too, if at all you want to visit during the daytime, not during the night time. Of course, this timing actually, as a retired police officer, I may not like, but these are the orders of the High Court. Of course, time and again they have been told, and the police people, definitely they will be going and checking his house also. But anyway, it's a good judgment. Whenever you want the rowdy sheet to be closed, then you can file this type of petition. Thank you.